Good morning, everyone. Welcome to the J&J Consulting Services receivership call. Today's February 11th, 2025 at 10 a.m. Pacific time. I appreciate everyone taking the time to join us for this call and allow us to give you an update as to what is going on in the case. As always, I want to give a legal and an accounting disclaimer that anything you hear in here should not be construed as legal advice. And if you have legal questions, we recommend that you reach out to a competent attorney to discuss, and the same goes with accounting. Anything we say in this call related to accounting should not be considered accounting advice. And if you have questions, please do reach out to a CPA specifically to ask questions. So really want to talk kind of, briefly as to what we're working on right now. The majority of the time has been spent the last few months really focusing on completing the forensic accounting, as well as an expert report that was required to be completed in the Wells Fargo litigation matter. And so we've been really diligently focused on that. The Wells Fargo report was due at the end of October, and then we had a rebuttal report that was due towards the end of December. Both of those were completed and turned in on time, and we've been going through the discovery process in the Wells Fargo litigation, including depositions and other activities. But we'd like to kind of switch gears a little bit and start answering some of the questions that were provided to us in anticipation of this call. So I want to start first, some of the general questions about how much has been recovered in funds and how those funds are being spent. That information is available in every one of our quarterly reports. We do provide all that information, so it is available to everyone who is involved in the case. As it sits right now, we have approximately $77 million in cash in the bank, as well as we have some additional assets that have yet to be sold, and some assets that we are working on and currently recovering, as well as potential clawback litigation against third parties and professionals, including banks as well. So that is, really kind of an overview of what that looks like. But as far as specific questions go and the specific accounting, like I said, we do provide that information in every one of our quarterly reports. I would encourage you to take a look at those. And if you have specific questions related to how the money, how much money has been collected and how it's being allocated, please do reach out to us, and we're happy to answer those questions. The next question has to do with providing detailed information about the amount of money that was brought into the scheme, the amount of money that was spent, how much money was returned to investors, and other related questions. So we, as I said, are working on the forensic accounting, which we do anticipate filing at the end of March. That report will immediately go up on our website and be available to view. And then that will obviously be the largest topic of conversations that we'll have in the next status report that we have, and the next call that we have with investors. And so we'll be able to go over that information and really give you more detailed information. At this point, it looks like the total loss is somewhere in the neighborhood of $240 million. That would be the loss that we believe investors would be owed at this point. That number is subject to still change a little bit as we do work through the final parts of our forensic accounting. Questions about third parties, about defendants and others. Says, while you're on the civil side, can you post criminal updates on the website for investors? We don't get a lot of updates, criminal updates provided to us. The information we get is largely the same way that most other people get it, and that's through the public record, including like the Las Vegas Review Journal and others. So we don't really have a lot to post on the website at this point. There's really been no change in any of the criminal matters since the charges were first brought. So we don't really have any update at that point. There's some investors asked some specific questions about which people are going to be charged, and we aren't privy to that information. That is ultimately up to the U.S. Attorney's Office who they choose to prosecute or not prosecute. Again, it's not our role to determine who's guilty or innocent and what that looks like. So we have no say in that. However, we will provide any information that we have that if we're issued a subpoena, or we will obviously cooperate with the various different parties involved in the case. Another question about related to defendant Jeffrey Judd and the document turnover request that we had filed, and then the motion to compel turnover. We have not yet received any documents from Mr. Judd. He does have approximately 1 week until those documents would be due to us. And depending on whether or not we receive those documents and whether or not they're complete, then that may lead up to further filings in the court related to a turnover of specific documents. Next question is, how much property did the defendants have? Again, we've gone through and disclosed the properties as we've sold them. There are some additional properties that we will be taking control over and selling in the coming months, and those will be added to that pool. People ask questions about whether or not specific defendants ever actually purchase contracts for themselves. As we go through and finish the forensic accounting, we're going to do our best to make those determinations and see what actually happened. And so so that information again will become part of our report that we file with the court in the forensic accounting. So we will disclose that information once we have an opportunity to do a review of that information and come to the conclusion there. Other questions about what some of the defendants are living off of if they're using ill-gotten gains. So all the accounts that that we were aware of and that the courts were aware of, and any accounts that we were able to locate have been frozen, and so those funds would not be available to individuals to spend. Most of the defendants, or at least all the defendants we're aware of, are also working to support themselves, and so I'm not aware of any individual who's living off of any ill-gotten gains. If you have specific information related to that, or think that there's something we need to follow up on, I would appreciate you providing that information to us so that we can make sure that, in fact, all those funds have been frozen as we anticipate that they have. Next section of questions regards litigation and third parties. Are there additional assets or legal claims that are actively being pursued to maximize recovery? The answer to that question is yes. However, typically before we file a lawsuit, we want to make sure we have a good understanding of what somebody allegedly took or was misappropriated to them as part of this scheme. And so once the forensic accounting is finished, we'll be in a position then to start filing those lawsuits against third parties to start that recovery. We do anticipate that there's a significant source of funds that will be available for recovery in those ways. Like I said, not only including clawbacks against third parties, but also against potential financial institutions or professionals as well. Are you still confident that we will be getting back some money from Wells Fargo? Yeah, I'm confident in our case. I believe we have a good case against Wells Fargo. As I said earlier, we have been going through the discovery process with them. We have exchanged expert reports. And at this point, we are finishing up some document discovery related issues. And then my hope is that we will be able to, again, mediate this claim and see if we can't come to some settlement. However, if we can't come to a settlement that is agreeable to us and to the court, then we will continue to pursue this matter to trial. And we are prepared to do so if necessary. We do know that now that discovery is wrapping up, that we anticipate Wells Fargo will file some motions to try to get the case eliminated, including a motion to dismiss or a motion to deny class certification. We don't believe that they have any strong claim for either of those. However, we will make sure that they are pursued diligently to make sure that we can maximize the return to investors out of this lawsuit. Next question is there a trial date set for Wells Fargo? There is not a date yet set because we have to finish the discovery process before that date will be set. But it does look like that if there is a trial, it will likely be in 2026 and not 2025 based on the court's schedule and what would be available. Next question is, do we have a sense that Wells Fargo wants to settle or go to court? Wells Fargo has also stated that they are, willing to take this to court if they believe that that is necessary. And we have not had any further talks of settlement, but we do anticipate that there will be some further settlement talks or even possibly mediations that will happen hopefully here in the short term. What is the status of the Wells Fargo lawsuit? Like I said, right now we're at the end of the discovery phase of this, which means now that they're going to attempt, to try to get the case thrown out. And of course, we're going to continue to defend that. And those issues won't be decided for some time, based again on the court schedule when those get filed. How much money do we estimate we will get from Wells Fargo? In previous disclosures, we have estimated that the claim could be worth up to $100 million. That does not necessarily mean that that is the value of that claim. We have to still determine what the value is based on certain parameters and the finding, obviously, of culpability by the court and what time period that covers. And so once, so it's going to be difficult to estimate it, but we're doing our best to maximize that value and get as much money as possible returned back to investors. The next group of questions has to do with assets. Specifically, somebody asked a question about the SBAR, which is one of the attachments to our report. Typically, it is one of the exhibits. The SBAR stands for Standardized Financial Accounting Report, which is an SEC accounting form that we use when we submit these documents. And their question specifically regarded line 14C, which is considered other assets or uncleared funds, asking what those are. Typically, the things that fall into that category would be litigation-related claims that we believe that we have. And so that's what that number is primarily made up of. And so when you ask about, when you see the total number of assets, the first number obviously is going to be the cash number. And then the other numbers are things like investments, which we anticipate being able to sell and return to the estate, as well as claims we have against third parties. How much money was invested in the Ponzi scheme? We believe over $530 million was invested. Again, that number will continue to fluctuate a little bit as we complete the forensic accounting, but we do believe the number to be in that range. Let's see, you said the last meeting, the amount to make everyone whole is estimated to be between $150 and $240 million. Please explain how this number works. So that is based on an analysis of how much money people invested versus how much money they got back. Again, we have not determined yet what kind of claims process there will be in this case or distribution process. But typically in these cases, it is going to be a money in, money out analysis. So you take the total money that was invested minus the total amount that was returned to the investor, and that would give them what would be their claim amount. And so we do believe that that number will fall into that range or somewhere very near that range. And then the distribution, again, that process has not yet been determined, but typically in these cases, it is a pro rata distribution, which means that everyone will get an equal % of their allowed claim. The next section deals with clawbacks. How do you plan to go after people that made money off of the scheme? And so that is part of the forensic accounting. We've determined, we are working on determining who exactly did profit from the scheme, whether they were investors who got more than their initial investment, or if it is other third parties that were promoting the scheme and were making commissions off of that. So we will evaluate all of those, and then we will look to recover those monies, beginning as soon as the forensic accounting process is finished. The next questions have to do with the claims process. Is it true that investor claims are currently at 400 million? We don't have the claims yet because we've not started the claims process. We can't start that until after the forensic accounting has been filed. But we do anticipate filing a claims motion shortly thereafter the filing of our forensic accounting report. And so we do anticipate, like I said, that those claims will be somewhere closer in the neighborhood of 240 million and not $400 million that the question asked about. If we recover significant money to cover all of the outstanding claims, will we get 100% of our loss back? Again, that is based on the total amount of recovery, and assuming that we recover, enough to pay investors in full, they will be paid in full. We will continue to distribute money out once the distribution plan happens. The court has approved the claims, and then we will get through that process. Next question has to do, says, for those of us who completed a detailed schedule of dates and amounts invested and received, we have to do that again before the amounts can be returned to us. There will be a claims process. That exact process has not been finished yet, so we don't know all the details of it. But our hope is to require as little information from investors as possible. Since we were forced to do a full forensic accounting, we feel like we have most, if not all, of the information we would need to do the claims process. And so we're hoping for a much more simple process than what would normally be, so that investors wouldn't be asked to send us bank statements and copies of checks and others unless there's some dispute about the amount of the claim that is outstanding. The next group of questions has to do with the distribution process. Are there specific steps or conditions that we need to meet before a process can begin? What is the timeline? So the process before we can do a distribution is we have to have approved claims by the court. And so, as I stated, our hope is to do a claims process starting just after the forensic accounting report gets filed. We will ask the court to allow a claims process to occur. So we'll file that motion, and then there will be a hearing, at which time the court will determine what that claims process will look like. And then we will do that claims process. Typically, a claims process will stay open anywhere between 60 and 90 days, depending on the number of claims and when they're filed. We begin processing those claims as soon as we start getting them. And we hope to work through all those claims, but we do anticipate that, as usual, that there will be a number of claims that will be filed at the very end, real close to the deadline. And so we will need some time after the claims process to go through and analyze all the claims and make a recommendation to the court. So that can take, some time depending on when those claims are filed and how quickly we can get them and start processing them. Once we have all the claims, that we will then file a claims motion with the court, asking the claim to accept or deny certain claims. And then as part of that, we will also ask that the court allow us to then do a distribution based on the amount of cash that's available, less any holdbacks that are needed for taxes or other questionable expenses. And so we do hope that to be able to get through the claims process and get a distribution done in 2025. Whether or not that happens depends on some factors that are outside of our control, including the court hearing, when the claims process gets approved, when the claims motion itself gets heard, when that gets approved, and then of course the distribution motion, and when that gets approved. Some of that will depend on the court schedule. Some of that will depend on whether or not we have objections or people that object based on their claims, and so that could have an effect on how long that process takes. But as part of the process of evaluating claims, we always work with people to try to get any objections dealt with as part of that process, so that it doesn't become a long drawn out process with the court. We really don't think that there's any reason for there to be a drawn out process. So we're going to continue to push it forward and try to get things wrapped up as quickly and as simply as possible. Next question is, what will the disbursement percentage be? Are we going to get back all of our money, and some other similar questions? Those questions are very difficult to say. We don't know what that final percentage be, because we haven't gotten back all the money that we think is out there. In fact, we think that there's tens of millions, if not hundreds of millions of dollars still outstanding that could possibly be recovered. Our goal is to get back as much of that as possible. We would love nothing more than to get back everybody's money. Now that's not always possible, and we will work through all the things that we have in front of us and deal with them in a way that is as organized and as logical as possible. We also have to do cost benefit analysis on trying to recover certain things, whether or not the cost to litigate something is going to be more expensive than the acquisition of that item, and as to whether or not if we go out and get a judgment, whether or not it's collectible against somebody. So we have to make those decisions, because we don't want to spend good money chasing bad money, and we also don't want to waste investor money trying to go after something that may not be anything anyway. And so we have to make some of those decisions, all of which will be discussed in our reports, and likely be subject to a motion with the court regarding certain types of assets. But we do continue to work through this. And one of the questions we got asked that isn't necessarily about distribution, but just is about this process in general. Who oversees what's going on here, and so the answer is there's a lot of people that are responsible for overseeing this. Number one is the judge who appointed me. She is responsible for making sure that things continue to move forward in the case, that we're spending money efficiently, and that ultimately that everything we do benefits investors. There's also the Securities and Exchange Commission, who initially filed this case. They review everything that we do as well, and make recommendations on things as we move through them. We discuss the case with the defendants involved and talk through some of the various different things that we're doing there as well. And so, as a neutral third party, it's our job to listen to everybody in this case and determine what's best overall for everybody involved in this case. And so, we work diligently towards that. But we do have a lot of people that are looking, as well as the investors, the attorneys, and others that are involved in this case. As you can see, almost everything we do is filed publicly. We tell everybody how the money's being spent, where the money's coming from, what we anticipate going after. Now, some of that doesn't always come out initially because some of it we have to do related to strategy and stuff. We don't want to give away strategy related to lawsuits that we're doing. Because we want to make sure we keep the edge so we can maximize the value that we get and return to investors. But otherwise, all the steps that we take are very public and everything is out there for people to see. And of course, we always encourage people to reach out to us if you have specific questions. There was a group of investors that had some concerns that reached out to me, and we had a conversation in December, and we're able to talk through some of the questions that they had. And so we're always happy to do that as well. My staff is here to answer any questions as well as myself. And we want to do that as efficiently as possible, but we do want to make sure that people feel like that they're being heard as part of this process. We understand that this case is taking what feels like a long time, and that it's been expensive, and unfortunately it has. And this forensic accounting has been a very large undertaking. We talked to a party who was looking at seeing what it would take to recreate the forensic accounting, and they determined it would take millions of dollars and take many, many years to complete. And so, we are obviously, doing that work and have done that work already, and so that will not be recreated into the future. And so, this process has been long. Unfortunately, I wish we had records. We have slowly started to get some of the initial records. Mr. Beasley did voluntarily turn over some of his emails and texts that he had received copies of. And we are working with the U.S. Attorney's Office to try to get the rest of the text messages, the emails, computers, and other things that were seized initially in this case and have been going through a taint review with the government. Our hope is that we still get access to those. We do think that information will be important, both for helping make sure that we have a full understanding of what happened, as well as litigation against third parties. We do think that there could be some very good information that is in there, and so we are still working as hard as we can to try to get that information. But it is a process, unfortunately. I'm going to spend just a couple seconds going through the messages that have popped up. One of the questions is, could the amount recovered exceed $100 million? Under the right circumstances, the answer is yes, it could. There's obviously some work we have to do to get there. That is part of the reason why we're hoping to get some of these text messages and other documents, because we do believe that will help us increase the amount of the settlement or ultimate trial and damages against Wells Fargo. The next question is, will there be punitive damages against defendants? Punitive damages are decided by the court. If we do determine that we are going to take a case to trial, we would request, we do request punitive damages as part of those trials. And we do think that there's a potential that that we could get punitive damages. So based on what you said about the total losses of $240 million, does that mean that that if you recovered $240 million, you'd be made whole? So we do believe that again, approximately $240 million is the amount that's outstanding to investors. So if we were able to recover that much, then we do believe that could lead to a potential recovery of all investors' original investments. What happened to the dispute with Judd's wife and her attorney? He was refusing to return money. I do believe that you're referencing Beasley's wife there, since we have not had a dispute with Judd's wife. But with Beasley's wife, we are still working through that process. And so that, as far as that dispute is still outstanding, the attorney refused to turn over the documents he was required to, has refused to turn over the money that the court ordered, and has since appealed it to the Ninth Circuit. That appeal is coming up in March, and we hope to have those issues decided at that time. We are still continuing to move forward, though, pressing to get those recovered, including depositions that we have scheduled against them, and additional work to try to determine what happened to the money and where we might be able to get it from. When will the forensic accounting report be submitted to the court for approval? What is the reason for continued delay? So there seems to be some misunderstanding on that delay. The The only date that we've ever provided for completing the forensic accounting report has been March 31st. Our hope was to get it done before that time. However, due to our obligations in the Wells Fargo litigation and the work that we had to focus on that piece of the forensic accounting to come up with what we thought were the damages numbers against Wells Fargo. And so that it will continue to be that March 31st date. And we do believe that the report will be filed on that date. And we don't anticipate any further delays from that. And so I'm looking forward to getting that report filed. I do think that there will be a lot of information in there that investors will appreciate understanding better, including, where the money went and how it was spent and where what we've managed to collect back. And so we will continue to work on that, that piece of it, and we'll continue to push up until the 31st. Looks like there's a question specifically about $100,000 ring. We have not seen that. I have not seen a ring that's valued at $100,000 or anywhere near that. So we will continue to look, for that information relating to Mr. Judd and make a demand for that property. If you have proof that that an asset was purchased and you have not seen it show up on our list of assets, we would appreciate you providing that information to us so that we can go after it and attempt to recover that type of stuff. When do you anticipate the first disbursement and what percentage? We do plan to make a first disbursement in 2025. Again, some of that is not within our control, but we're going to do everything we can to try to make sure that happens. What that exact dollar figure will be based on the amount of money that is available at the time that the distribution is approved. Less, like I said, any money that has to be held back for taxes or anything else that would need to get we would need to make sure that we had funds for. Approximate date for the distribution. I can tell you the hope is to start claims in the second quarter and to have the motion filed within the third quarter. And so, just based on that math and the amount of time there, I would anticipate that a distribution would probably be in the fourth quarter. But it could be, slightly earlier than that or slightly later than that, depending on, again, if people object, if there's hearings, how long those hearings take, and then other, ancillary things that may come up that might be out of our control. Questions about, do the attorneys get a percentage of return monies? Or are they strictly hourly? So the attorneys that represent the receivership estate are working on an hourly basis. The attorneys that are doing litigation related work typically work on a percentage recovery basis. Both of those rates, both the hourly rates and the percentage recovered, are both negotiated rates. So they are lower than what they would normally be in the open market in order to try to recover as much money as possible. And then the question was related to why was this meeting postponed until today? Unfortunately, some of what we do in our schedules, is within our control and some of it is not. We do have certain obligations that we have to the court, to the commission, and to the defendants in the case. And so sometimes that causes these meetings to get moved around a little bit. We try to not do that whenever possible. We do try to keep the schedule, but every now and then we end up in a situation where we're just forced to move dates. So I do appreciate everyone being patient with that. The next question is, are the recovered funds invested at interest? Yes, so the funds do draw interest. We made approximately $1 million in interest in this case in the last year. We are always looking for ways to increase the amount of that return, but we also have to protect the money and make sure that it stays insured, which is tricky in today's environment. And so we are always looking for ways to maximize that. I wish we could get a little higher interest rate than we can, but again, because we have to protect it and insure it, that does come at a cost. But the amount of money that we're talking about, it's critical that we're able to to protect that money, because we want to make sure it gets back into the hands of people. Next thing, why would investors' money in a Ponzi scheme be subject to taxes? So investors' money isn't necessarily, although what ends up happening in the way that some of the transactions have been recorded and taxes have been filed can lead to there being outstanding taxes owed. We always hope that that is not the case. We do have a significant amount of loss related to investor loss. And so we don't know that there will be tax liability, but we always have to reserve for it, because if you spend the money that the IRS believes is theirs, it creates quite a problem for everyone involved. And so we just have to make sure. And so usually what we will do, before a distribution is we meet with our tax accountants, have a discussion about what we know being outstanding. And then if we feel necessary, we may make a small reserve for that. But again, it's on a case-by-case basis. Like I said, we will make that judgment at the time that we file the distribution motion. If people think that the amount should be different than the amount that we are recommending, we are always open to listen to that. But we just need to make sure that that the estate is protected as well. Again, somebody asked another question about lawyers and the percentage recovered funds. So like I said, the people that work on the receivership itself are on an hourly basis, the attorneys that work on it. The attorneys that work on the litigation, so right now the Wells Fargo litigation, for example, those attorneys are getting paid based on a percentage of when the case gets settled. Usually it's one percentage, in mediation, another percentage if it goes to trial, a different percentage if it goes on an appeal. And so so those parties will be paid on that. Both the class action attorneys and the attorneys that are representing the receivership in that Wells Fargo litigation are all working on a contingency, and they are all working on the same contingency fee. So it will be split amongst all those attorneys, and there's not going to be different groups that are going to get other percentages. So the percentage that you see that get filed when we file those documents, that is the total percentage that will be paid out on it. And again, we always push for discounted rates. Typically on a like a class action case, it's not uncommon for the attorneys to take 33 or 40% of the settlement, and we have reduced that down significantly from that, so that we can try to return as much money as possible. Somebody asked us to repeat the approximate net dollars recovered that would be available for distribution. Like I said, as of today, we have approximately $77 million in cash. Some of that cash is in the Beasley Law Group trust account, which we have taken control over and have actually transferred the funds out of there. But we would also have to get permission of the court to combine those funds once so that we've been able to show that there aren't any legal client funds involved in that total. And so we will continue to work through that as well. And that, like I said, that number will continue to increase. We are selling assets, on a regular basis. We will be recovering some additional assets. I anticipate this quarter as well as into the coming quarters as we start to go after third-party targets. Next question, fourth quarter. So what was initially a possible first quarter distribution is pushed back to the fourth quarter. What is taking so long? Again, I continue to hear this, that this forensic accounting was supposed to have been done last year. That number I'm not sure where that date came from. As I said, we've continued to push this March 31st date. That's what we've told the court all along. That's what we've put into our reports as we've gone through this. And so our hope is that we can get that distribution out as quickly as possible. My hope is that the claims go very, very quickly, but the court is going to be required to leave that claims process open, either somewhere in the 60 to 90-day range. If I can get, we are going to send out what we anticipate sending out a form that would just allow people to sign the form saying that they agree with our math on their claim, assuming that we can get those all done quickly. And that we don't have a lot of objections. We hope to then be able to file the claims approval motion shortly on the heels of the process ending. But if we get a lot of claims, at the deadline, or if we have a lot of people who object to the way the claims are calculated, then that could cause additional time, or it could take additional time. The question is, how many investors are in the pool? Right now we know that there are approximately between 1,300 and 1,400 people that invested. We don't believe that all those still are owed money, so that number will actually, the number of claims that we receive will be less than that. But like I said, until once the forensic accounting report is filed, we will detail the exact amount that is the exact number of investors. But as of right now, the number is somewhere between 1,300 and 1,400 that invested in total. What other information would you need about our claim? Again, we don't anticipate that we'll need much, if anything, from investors. There may be a few investors that we have some specific questions about. There will be, people from my staff have been reaching out to investors and to other people recently. So we want to make sure that, if somebody from my office reaches out to you, please do respond to them as quickly as possible. The other thing too is there are some investors that we don't have contact information for. We know that they invested because we've seen them in the bank records, but we don't necessarily have addresses for them. And there's a handful of those that are outstanding. So if you do know people that have invested and they have not been in contact with us, I would ask that you encourage them to reach out to us either via phone, email, or on the website, and provide us their contact information so we can make sure that they get information about the claims process when that starts. So that's all the questions I'm going to be able to answer for today. And so I do appreciate everybody taking the time again. If you have specific questions or if you have information related to specific assets, please do reach out to us directly. The information was just posted in the chat there, but as a reminder, the website is jjconsulting-receivership.com. Again, that's jjconsulting-receivership.com. There is no and in there for the J and J. It's just JJ because an ampersand can't be used in a website. So please, if you need to go to our website, the email is contact@jjconsulting-receivership.com. Again, that's contact@jjconsulting-receivership.com. Or you can contact us at area code 702-832-2299. Again, that's 702-832-2299. Again, if you have any questions, please do reach out to us. We're happy to answer any questions you might have. I appreciate everyone's patience. There's going to be a lot of information that's going to come out in this next forensic accounting report. And so I do anticipate that the next call that we have will be a longer call because I'm going to take the time to go walk through that report, not only to answer questions, but just to walk through some of the findings that are in that report. And so, do anticipate a longer call for the next, the next call that we have. And once that report is published, it will go up on the website, and we will send out an email letting everyone know that it has been placed on the website. So again, thank you for joining the call, and please do reach out if you have specific questions. Bye-bye.